It's like, yeah, you can start the session.
Good evening, everyone. A warm greetings to everyone. I am Lekia R, co-host for this webinar and fourth-year law student, BBLLB Honors from ICFA Law School, Hyderabad. I would welcome each and everyone who are present here in Zoom meeting and also people who joined us on YouTube Live and other social media platforms. Sri Venkateshwara Law Students Association, SVLSA, cordially welcomes each and everyone to the 7th National Legal Webinar on Cyber Laws in India by our respectful and our versatile speaker, Ms. Kanika Bhardwaj. I would like to take the privilege to welcome our organizer, Mr. K. Pavan Kalyan, to the webinar. Welcome, sir. I would also like to take the privilege to welcome my co-host, Mr. Hari Krishna, sir. Welcome, sir. I would also like to invite cordially Ms. Kanika Bhardwaj, ma'am. Welcome, ma'am. Thank you for joining us today. And we are eagerly waiting for your webinar. Now, I would like to hand over the mic to Pavan Kalyan, sir, the organizer of this webinar, to speak few words.
Thank you, Lekya. But one correction, you are not visible, so please check once. And Sri Venkateshwara Law Students Association, SVLSA, established in 2022 in order to spread the legal knowledge to all the law students by conducting academic activities with legal luminaries in India. Until now, we have conducted 9 webinars all over in that are 8 national webinars and 1 is international webinar. In the national webinars, we have conducted people from the legal fraternity and give their insightful knowledge on the legal practice who had an eminent expertise in law. With the help of Sri Venkateshwara University, Tirupati, we have conducted online legal webinars as university law students from the 5 years BLLB Department of Law in our own individual capacity. Had been conducting legal webinars, we have got very nice response by students from different universities, colleges. We decided not to stop with only a few, but to expand the reach of these academic activities that we involved to all the law students around India. Under our association, SVLSA, Sri Venkateshwara Law Students Association, so that every law student will have the exposure of legal teaching from the legal luminaries of India in the legal fraternity. Our main mottos are to learn legal knowledge from luminaries, expert in the subject of law, and to promote a better understanding of communication among the law students all across India in the subject of law. To evolve and impart comprehensive legal education at all levels to achieve excellence. to disseminate legal knowledge by organizing lectures, seminars, symposia, workshops, and conferences. As we have mentioned already, our motto behind doing these academic activities, our only intention is to make sure that as law students, we are well equipped with to the knowledge and up to date. There is a difference in regarding and understanding theoretical knowledge, but what we need at most as a law student is the practical exposure of the law and how things are happening at present in the court of law. We want every law student to be part of this family and involved in our work. We welcome all students of to be part in these activities. Thank you, Lekya, and most thankful Kanika Bhardwaj ma'am for accepting our request. Thank you once again. Thank you, Lekya. Lekya, you are not audible.
Is it clear now?
Yes, now.
Yeah. Thank you, sir. Thank you, Pawan. Thank you for saying about the association and the other achievements. Now, I would like to take the privilege to give a brief introduction about
Sorry, you are not audible properly. Please check once your connection.
I think she's not audible. Maybe some connection issues.
Yes. Like, please check once. Okay. Okay, I will continue with ma'am's bio. Kanika Bhardwaj ma'am is founding partner of a full-time law firm, Kanika Bhardwaj Law Firm, having an office in South Delhi. She is the field of litigation for 9 years approximately. She completed her
real estate, insurance, debt recovery, related cases. She has been marking.
Like, I think you are not audible properly.
Okay, so I think I should
Clear now?
because it's okay. I'll start with the session if you allow me.
Yes, ma'am. I just completed, ma'am. It's
Yeah,
few
it's okay.
She completed her LLB from Lloyd College and have completed masters in business laws from Amity University. She has expert level experience in matrimonial, criminal, domestic violence, family, corporate, 138 NI Act, civil, real estate, insurance, debt recovery, insolvency, drafting and vetting of documents, labor and business law related cases. Presently, she is working on cases all over Delhi, NCR, and Mumbai in all district courts, High Court of Delhi, High Court of Mumbai, and Supreme Court of India. Apart from courts, she is also working in cases in various tribunals such as CAT, RERA, DRT, NCDRC, and MCD. Also, she is in the panel of Yamuna Expressway Industrial Development Authority, Noida, UP. We're glad to have you, ma'am, in our webinar to have your insightful knowledge on cyber laws in India. Please take over. Thank you.
Mr. Pavan, thank you for such a nice introduction. And so, first of all, I would like to thank the entire association for having me here. And I've chosen this topic particularly because, it's a very interesting topic. And on the other part, if you see, it's a rising topic. In India, in pan India, I would say there are like several states, several local authorities, we are experiencing a lot of cybercrime. And cybercrime is vast. And because cybercrime is vast, the other thing is that the particular field is also not very well established in India, because we are experiencing a new type of cybercrime every day. And India, I believe, it is at this point of time, it is not ready. The laws are not well established, and the investigation process is not well established in India. So it is very important to keep ourselves aware, being a law students and being a budding lawyers, because ultimately what will happen when a case will come, or any particular situation arises, or any particular client will come to you in regard to the cyber crime. Obviously, you have to entertain that particular client, or you have to entertain that particular citizen of India. And as of now, we don't have awareness. There is a lack of awareness, lack of the entire legal establishment. So it is very important to keep ourselves aware and keep conducting sessions on cyber crime specifically. So this is
Hello.
the I have chosen so this is the reason I have basically chosen this particular topic. Now, when we talk about cyber crime, we know that cyber crime in India has been rapidly evolving. So every day, in fact, you get to hear different tricks of scams, and many other offenses are being committed on, particularly on cyberspace. There are many cyber crime in India. There are many victims who are left clueless, who don't have any clue, as I believe there is lack of, why they don't have clue, because they have lack of knowledge. There is a lack of awareness among people in regard to cyber laws and procedure. So this is what is happening. For example, I would like to give you a very recent example. There was a case where all the companies used to collect data online. Okay. Now there was one of a company which was a startup of toys. They were basically producing toys for newborn babies. Now that company started collecting data online of those women who were pregnant. So they decided to promote themselves by sending them free sample of toys. So they started sending free toys to those ladies on the basis of collected online data, and they used to send a greeting card which says congratulations on becoming a mother. Now there was a girl who didn't want to tell her family about her pregnancy. Okay, so now what that company did, they sent them a toy also, and they sent them, her a greeting card also, stating that congratulations on becoming a mother. Now, with this act, everyone in a family, everyone in the neighbor got to know that she's pregnant. So what this company has basically done, this company has pirated, this company has violated the right of privacy of that particular girl. So this is what, this is one of the recent examples that I am working on as of now. That girl wants to sue that company. I wouldn't take the name of the company though, but that girl now wants to go ahead and ask for damages from that company. So this is a recent case that I'm working on. So these are the crimes which are happening. Apart from this, also there are several cyber crimes in India which are on peak as of now. So one of it is cyberbullying. You must have heard about cyberbullying, I'm sure. A cyberbullying is someone who harasses or bullies other using electronic devices like computer, mobile phones, and any electronic device, laptops, etc. So cyberbullying refers to bullying conducted through the use of digital technology, the use of social media, messaging platforms, gaming platforms, and other mobile devices may be involved. Oftentimes, this involves repeated behavior that is intended to either scare, harass, or shame the other person out there, or that, or a person who is committing cyberbullying. He may be wanting to extort some money. He may be wanting to blackmail the other party. So this is one of the crimes, cyberbullying, which is at the peak at this point of time in India. The other one is cyber grooming. The phenomenon of cyber grooming involves a person building a relationship with a teenager and having a strategy of luring or teasing or even putting pressure on them to perform any sexual act. This is called as cyber grooming. Again, this is on the top as of now. Online job fraud is there, which is increasing day by day. An online job fraud scheme involves misleading people who require a job by promising them a better job with higher wages while giving them a false hope. On 21st March 2022, the Reserve Bank of India alerted all the people not to fall prey to job scams. The other one is online sextortion. The act of online sextortion occurs when the cyber criminal threatens any other individual to publish sensitive and private material on any electronic medium. This particular type of cybercrime is on the peak in Delhi as of now. I don't know about uh, other states, but in Delhi, this particular cybercrime online extortion is on peak. Apart from that, credit card fraud and debit card frauds, I'm pretty sure you must have heard about all these. These are very old type of frauds now. And the other one is phishing, and impersonation and identity theft. All these things comes under cybercrime, and not the cybercrime is not limited to only these heads. The crime, such type of crime is like vast. So even cyber stalking is involved in all these things. Even online trolling involved in cybercrime. So all these things are cybercrime. So in India, cyber crimes are covered by majorly by two acts. So as a law students or as a budding lawyers, we should know that now I would like to inform and notify all of you guys that cyber crime is one of the very upcoming field in which a particular student can make a career in, because cyber now is now going to established from day to day. It is going to be established now, so it can be one of the field where you can also make a career, and you can also make a very good amount of money in all such cases. Because in Supreme Court we are experiencing several writs and several SLPs and all these things related to the cyber crime. So the lawyers who want to the students who particularly want to establish their career in cybercrime is a very good upcoming field as of now. It's an emerging field, I can say. So as a law student, you should know that which laws basically or which act basically covers cybercrime. So in India, when we talk about India, there are two major acts which covers cybercrime. So the first one is Information Technology Act 2000, and the other one is Indian Penal Code 1860. So these are the two major acts and IPC and the code which covers every possible crime of cybercrime. So it is the Information Technology Act which deals with issues related to cybercrimes and electronic commerce. However, in the year 2008, yes, 2008, I guess, yes. In the year 2008, this act was further amended and outlined the definition and punishment of cybercrime. So several amendments to the IPC were also done in that particular year, and the Reserve Bank of India had also, made certain notifications, made certain rules and regulations considering the rising of cybercrimes in India. So as of now, because we are covering only the basic knowledge of cyber law as of now, I would like to point out the silent features of Information Technology Amendment Act. So I would like to point out the amendments that has been done recently in the IT Act. So recently the term digital signature has been replaced with electronic signature. So any sort of electronic signature now online, this has been amended. And the act has been made more neutral now, because earlier there was like less provisions for cybercrime. There were less provisions of online crimes and all these things. Even the e-commerce was not particularly and clearly mentioned in IT Act. But now, after the amendment, the term digital signature has been replaced with electronic signature. The entire process of investigation has been now given in IT Act. The e-commerce websites and all the e-commerce work, e-commerce startups have been, added in IT Act. So these are the amendments that have been done by the legislation. Now a new section has been inserted to define communication device. So earlier there was no such mention of communication device in the particular act of IT Act, but now a new section has been inserted to define communication device to mean cell phones, personal digital assistants, or combination of any other advice used to communicate or send or transmit any text, video, audio, or images. Now, because earlier there was no mention of communication device only, earlier there were only one particular device which was mentioned in IT Act, and that was computer. Nothing else was mentioned. Now the IT Act has involved all the cell phones also, any personal device, anything that is used to transmit any text, message, audio, or image. So this has been a very major step taken in the IT Act. Apart from that, a new section has been added to define cyber cafe as any facility from where the access to the internet is offered by any person in the ordinary course of business to the members of public. Another section, 10A, has been inserted to affect the contracts included electronically, because earlier, because there was no much e-commerce websites and everything, there were no contracts, there was nothing. But now, because there are contracts also, so in regard to the contracts, electronic contracts and everything, a new section 10A has been inserted. So earlier in the IT Act, there was a damage of 1 crore rupees. If you will see section 43 of the IT Act, it used to say that if any person has been, any person has committed cyber crime, or any person is liable, he will pay damage of 1 crore rupees. But now this particular provision has been deleted, and it has been said that the person who will be liable, who is caught basically, will be liable to pay damages, and the damages depend upon the circumstances of the case. It can exceed 1 crore also, or it can be like less than 1 crore also, depending upon the circumstances of the case. So this has been a recent amendment in the IT Act. Another section, if you will see section 66A to 66F, all these sections are related to cybercrime only. Section 66A to 66F. So it involves everything. It involves identity theft. It involves cheating by impersonation. It involves violation of privacy and cyber terrorism. Any obscene act or obscene messages, stalking. So all these things are covered from section 66A to 66F. And this has been amended. Recently, there was no such, previously there were no such sections, but they all have been amended. Now, apart from that, section 67 of IT Act 2000 has been amended to reduce the term of imprisonment for publishing or transmitting obscene material in electronic form to 3 years from 5 years, and increase the fine thereof from 1 lakh to 5 lakh. So now earlier there was only a fine of 1 lakh, but now there is a fine of 5 lakh when it comes to transmitting obscene, obscene material or something like that. So these are the recent amendments that have been done. Now, a very important part I would like to discuss from you is that people keep asking that whether if any person has trolled a person on social media or has tried to defame the person on social media. For example, there are several comments on or the photographs, and there are several other things also on the social media nowadays. So whether any person can take action on them. If any person has tried to defame another person socially, online, by any commenting, by trolling, or any such kind of a thing, what can be done, or if something can be done or not. So the very clear answer to that question is that yes, if in case anybody is trolling you, or if anybody is trying to harm your reputation online, either on Facebook or Twitter or Instagram or any such social media, that person can file a defamation suit. So defamation is a remedy now. Okay, so I'm telling you all these things because it is important that you all should know that if anybody asks you that someone has been trying to destroy my reputation online and have been commenting and trolling, then what I should do? Then you will tell that defamation is your remedy. You can file a defamation suit. So defamation comes under the libel. You must be knowing that there are two forms of defamation. One is libel, one is slander. So this kind of defamation comes under libel. So defamation suit can be filed, and you can ask for damages and compensation also. So this is very important, a thing that everybody should know. So this was the IT Act. Apart from that, there is IPC also. So whenever such cybercrime has been committed, as I have already told you, that IT Act is involved, and the other code that can be involved is IPC, Indian Penal Code. So, for example, if there is any stalking online, or there is any grave or serious offense that has been made, which is from the cybercrime, which comes under the cybercrime, then IPC will be involved. Okay, so because of the rising number of cybercrimes, the legislation has made certain amendments on IPC also in regard to this. So now the first very important amendment that has been done by legislation in IPC is Section 4. Okay, so Section 4 of the IPC now, it has been amended, and it has been said that any person without and beyond India committing offense targeting or computer resource located in India will be liable. So now you have to understand, if there is any person who is sitting outside India and he's committing an offense in India, that person will also be liable. Okay, so earlier there was no such kind of a provision in IPC. So what happens when the sections of IPC is attracted? What happens? Number one, there is a possibility to, there is a possibility to, just a second, guys. Yeah, I'm sorry. So now what happens when the provisions of IPC is attracted? Number one, FIR can be done. So when the FIR is done, obviously the trial will be in the court. Now when the trial is in court, the proper investigation will be done, the proper judgment will be there, and that person can be either be imprisoned or can be, liable for the penalties and fines. So this is what happens when a particular section of IPC is involved. When it comes to IT Act, in IT Act, the time period of imprisonment is very less. And in IPC, the time period can be either 3 years, 5 years, or something like that. So whenever the IPC is attracted, it means that it's a very serious, offense that has been committed under the cybercrime or otherwise also. So now Section 4 says that if there is any person who is sitting outside India also, let's say in Canada, Hong Kong, wherever, and he's committing certain crime through the computer or through any electronic device in India, that person will be held liable. Okay, so this section has been amended now. Apart from this, there is Section 464. Again, 464 says that, the word digital signature has been replaced now with the electronic signature. So this is a few amendments. Apart from that, when it comes to the girl, because nowadays several online crimes are being, occurred against the girls, where the girls are the victim. Let's say stalking is there. Okay, any person can, make her videos, can involve her in pornography, can blackmail her, try to extort money from her. Very serious offenses can be done. Her photos, her videos can be circulated, and her without her consent, obviously, and the other person can try to harm her modesty. So for all these cyber crimes, IPC will be attracted, and Section 354 of Indian Penal Code, which is outraging the modesty of a woman, can be attracted. So what I mean to, why I'm explaining all these laws to you, because I mean to say that nowadays there is a remedy, because gone were the days where, the victim of cybercrime was targeted also, and he was cheated upon, and then he was sitting clueless, he doesn't know what to do. But now I'm telling you all these laws for the reason being that now the process has been changing. There are established laws which are yet to be more established though, but there are established law nowadays where you can, we can go to the police station, or we can go to the court for our remedies. So this is why it is important to first know the amendments and the laws. Although we have very less time, so I'm only being able to tell you very basics of this, but the field is vast. Apart from this, you must have heard about Data Protection Bill 2001. This protection bill has recently been withdrawn for some more changes. This bill has been withdrawn in the Rajya Sabha and Lok Sabha by the parliamentaries. But yes, this bill will be established in India soon. It will be passed in India soon. Data Protection Bill, and this data protection bill will be so vast, will be so there will be proper investigation process defined. It will be very well mentioned in the particular act that, which authority will be liable if there is any cybercrime or anything like that. So this particular law, even in Western countries, this kind of law has already been established, but in India it is yet to be established, and we are just waiting for this bill to get passed. So now, when we have a basic knowledge of what cybercrime is and what acts are involved, we should know that what a person has to do when he becomes a victim of cybercrime. So this is very important. I'm pretty sure that you can go to the Google, you can search for the sections, you can read about IT Act, you can read about IPC, but this is something which people generally practically don't know, because as we are the law students and we are in the field of the law, we should know that bookish knowledge and practical knowledge are two different things. Okay, we are learning the laws and rules and regulations from the book. We do understand that, but then we should know how to apply that also, because bookish knowledge is different. And when it comes to practically, when you have to apply all these rules and regulations practically, you're point blank. So you don't have to do that. Okay, so even in cyber law or in any other field also, and in your general practice also, you being law students, you should know that whatever you are reading, you should know how to apply or implement that also. So now we have gone through the basics of the amendments and everything. So now we should know that what you will do or what the victim will do if he's one of the victim of cybercrime. So we'll study that step by step. So first thing, obviously, that a person has to do is online complaint. Now, either you can go to physically for the complaint, you can go to cyber cell also. There are now cyber cell established in the country. If there is no cyber cell in the country, and why I'm telling you all this, I'm telling you all this because, as I've already told you, there may be a client in future who comes to you and who explains about his case in regard to cybercrime to you. So you should know that what exactly you have to do. And even if anybody in your neighborhood or even you are the victim, I hope you are not the victim of cybercrime, but in case you are the victim of cybercrime, you should know that what you have to do. So the first thing is that you have to do online complaint or offline complaint. Both can be done. Online complaint will be done on www.cybercrime.government.in. Offline complaint will be done either in the cyber cell or in the police station. So this is the first step. You have to go on the website called cybercrime.government.in and register your complaint. Apart from the physical complaint, you should do apart from the online complaint, you can do physical complaint also. As we know, the laws and procedures for cybercrime has been still developing in our country. We should report on every possible platform in order to get relief that we want, because right now we know that procedures are not that well established. So whatever platforms we have, whatever authorities we have, we should go and just inform through a complaint that this is the thing, this is the incidents that has happened. Now the next step, according to IT Act, a cybercrime comes under the purview of global jurisdiction. So this means that a cybercrime complaint can be registered with any of the cyber cells in India, irrespective of the place where it is originally committed. So this is very important. It is not the case that whether a particular crime has been committed in local area, you have to go to that cyber cell only or that police station only. You can go to any cyber cell. This has been mentioned in IT Act. Okay, so when filing the cybercrime complaint, you need to provide your name, contact details, address, and in case you are a girl and you're a victim of cybercrime, which you don't want to, let people know, you can keep your name anonymous also. So it is not important. You being a girl, it is not important to disclose your name or address or anything such like that. You can be anonymous and still you can file a complaint in cybercrime cell. All right. And in case you are a man, then even there is particularly no law if you're a man that you can keep yourself anonymous. But if there can be later on, there can be provisions. For example, there is a provision in data privacy law that is coming, that is not established right now, but that is coming. The law will be passed. So in that particular act, there is a provision for male members also, male citizens also. But right now in this particular act, there is no such provision. But in case you're a girl, you can keep your name anonymous. So now in case you're a victim of online harassment, a legal counsel can be approached. Obviously, you have to keep a legal counsel by your side, so that some technicalities are not missed. So now in the coming era where this cybercrime will be more emerged and it will rise from day to day, the people who are practicing in cyber crime field, those lawyers will be actually, they can be the one of the best paid lawyers also, because in every case there will be one lawyer that has to be engaged. So that is why I've, in the very initial stage only of this seminar, I've said that this particular field can be a very good field for the budding lawyers nowadays. So now after registering your complaint, when your complaint is registered, you will get a phone number of concerned officials who will further investigate the matter. In case they don't give you number, you can ask them for the same, because every complaint and every investigation officer is appointed and that person is, has the duty to tell the status of the investigation. So if they don't tell you the status of the investigation, you can directly go to the court and file an application to know the status of the particular complaint. Okay, so in case there is any police official, any IO, any investigation officer who denies or who do not take any action on your complaint, on the basis of that complaint, you can directly go to the court, file an application, and say that this is the incident and police officials are not investigating the matter and they are not doing anything. So this is the provision that you can do right now. So once the investigation is done, either through police officials or either by the court, your issue comes out to be genuine. And if your issue comes out to be genuine, then you have to, coordinate with the IO. And then the entire matter, either the court will take the cognizance of the matter, or either the police station will investigate. The FIR will be done. Once the FIR is done, then the normal criminal proceedings will start. So this is how the entire process goes on. Okay, and what can be the remedies? What you can ask? You can ask for damages. You can ask for compensation. You can ask for, your mental harassment and mental torture damages and all such kind of things. Apart from this, there can be imprisonment also. Okay, so these are the remedies that you can get in cyber whenever you're going and filing a cyber crime case. These are the remedies that you have to ask from the other party. You can ask for compensation. You can ask for your harassment charges. You can show that this is the amount of this is the amount of financial loss that has been occurred to you in case of there is a corporate or a company or something like that. And if in case there is another type of a crime where money is not involved, then you can ask for compensation. Where the money is involved, for example, there is a debit card or credit card fraud where the money is involved and the person has taken 2-3 lakh or 5 lakh or whatever XYZ amount of money, then you obviously will claim that amount of money from the court. But in case there can be offenses, for example, there can be stalking, there can be cyber trolling, there can be trying to harm your reputation, all these kind of the cyber crime cases. In that case, you can ask for compensation or harassment charges. So these are your remedies. Now, apart from this, if the crime is more serious, for example, the sections of IPC are attracted, then imprisonment can also be there, and there can be fines and penalties also. So if there is a very serious kind of a stalking, or if a person has if a person has circulated a particular video of a girl and all such kind of things, then also that particular person can also be imprisonment. And the imprisonment, the amount, the time of imprisonment depends upon the case to case. So there can be like 3 years of imprisonment, 5 years of imprisonment, depending upon the particular case. So now, apart from all these things, I would like to also touch a particular topic called evidence in cybercrime. So the definition of evidence has been amended to include electronic records also. So earlier there was no such kind of definition of electronic records or anything. There was no such kind of definition in the Evidence Act, but now the Act has been amended, and the Act has included electronic records also. So the definition of documentary evidence has been amended to include all documents, including electronic records, produced for the inspection by the court. So Section 3 of the Evidence Act 1872 defines evidence, which means all statements which the court permits or requires to be made before it by the witness in relation to matter of fact under inquiry. Such statements are called as oral statement, because that is very general. Any witness who wants to give any oral statement in a particular case, because what happens in cybercrime cases is that it is very difficult to prove a particular cybercrime. The case can be registered, the complaint can be registered, but how will you give the evidence? How will you prove a particular case? So in that particular sense, if we talk about, there can be oral evidence also, there can be witnesses also. If there is any particular witness who is ready to come to the court and give the statement on the behalf of the victim, then that particular victim comes under the oral evidence, and that is allowed. Apart from that, all documents, including electronic records. Now, there are many people who keep on asking that whether the WhatsApp chats, and whether the WhatsApp audios, WhatsApp chats, all these things, whether they are admissible in the court or not. So answer is yes. they are very much admissible. So if you have any WhatsApp chat which is relevant to your case and comes under your defense, it can be produced in the court, but you have to give an application of section 65B. You have to give a certificate of section 65B, and once you give this particular certificate, then that particular electronic record can be admitted in the court. So all documents, including electronic records produced for the inspection of the court, are admissible. Such documents are called documentary evidence. So electronic records are now considered as documentary evidence. The term electronic records has been given the same meaning as that assigned to it under IT Act. So IT Act provides for data record or data generation, image, sound. So if there is any data, if there is any record, if there is any generated image, sound received or sent in an electronic form, emails, the screenshots, everything is covered under electronic record. So the definition of admission has been changed to include a statement in oral, documentary, or electronic form. Earlier, it was only oral and documentary record. But now, since the cybercrime has been increasing and there are so many electronic faults and crimes and everything, so now the definition of admission, which is section 17 of Evidence Act, has been changed. Earlier, it was only oral and documentary evidence which were admissible, but now electronic form of evidence is also admissible in the court, and it is relevant. So it is important to know all these things. Apart from this, a new section 22A, has been inserted into Evidence Act to provide the relevancy of oral evidence regarding the contents of electronic records. It provides that oral admissions regarding the content of electronic record are not relevant unless the genuineness of the electronic record produced is in question. Okay, so point to note here is that first you have to prove that the electronic record that you are submitting in the court is genuine. For example, there are many, people, they're very oversmart people in our country. They can, either edit a particular sound, edit a particular photograph and produce in the court. So that all these things, in order to stop all these, misusing of things, the court has said and inserted section 22A. So 22A says that when you are producing a particular electronic record in the court, you have the burden. The burden is basically on you to prove that this particular electronic record is genuine. Okay, so this is now section 22A. Apart from this, section 65A and 65B are introduced in Evidence Act under the second schedule to the IT Act. Section 65A provides that content of electronic record may be proved in accordance with the provision of 65B. The computer holding the original devices does not need to be produced in the court. A printout of record or a copy of CD or hard disk, floppy, pen drives can be produced in the court. So, for example, if there is a phone, we have to get into this. So, for example, there is a particular phone from which a recording has been done, or video has been recorded, or image has been recorded, then it is very easy to bring that phone before the judge to prove that the electronic record from this phone is genuine. The video has been recorded from this particular phone. The image has been taken from this particular phone. But it is when the crime is done from a computer. So it is very difficult to, bring the entire computer before the court. So now the court says that it is not necessary that you have to bring the entire computer in the court. You can give a pen drive. You can give a particular screenshot. You can bring a floppy also in the court. There can be a CD also in the court. So all these things can be done. So this is defined under section 65A and 65B. Okay. So now, apart from that, the law enforcement agencies face a new challenge dealing with cyber crimes. Criminal acts are being committed and the evidence of these activities is recorded in an electronic form. Evidence in these crimes is almost always recorded in digital fashion. It is important that computer security professionals be aware of some requirements of the legal system and understand the developing field of computer forensics. So now this is also very important field that we have to develop the computer forensics department, because if and when the computer forensics department is not developed or not built, then obviously it will be very difficult to reach the victim and reach the victim and reach the criminal also. It is very important to investigate a particular crime in a very good manner. So for this, the government has to think about increasing and improving the abilities of computer forensics department also. So the reality of the information age is having a significant impact on the legal establishment. One of the major area in which this is being felt is that of the acquisition, authentication, evaluation, and legal admissibility of information stored on a magnetic and other media. So all these things can be done. So when it, in context of photographs, when we talk about photographs, when a photograph is introduced as an evidence in the court, the context in which the photograph was taken and the degree to which the photograph matches the original recording, both are questioned in the court. So it is very important to tell you all these things, because there can be a time where you will be fighting your own case in the court. You're the law students as of now, you will be a lawyer one day, and then you will be taking and handling independently your particular case in the court. So it is important that you should know that when you are dealing with cases of cyber crime or when you're dealing with the incidents of cybercrime or any such type of a matter or issue, what exactly you have to do. So I have told you that two acts will be attracted. One is IT Act and other one is IPC. I have told you the remedies also, that what remedies can be, what remedies can be asked from the court for the victim. Now I have also told you about the basics of evidences that you can produce in the court. So that is why I'm telling you about the photographs also. So when a photograph, if you are submitting a particular photograph in a court record before the court, so you have to see that the court will also check the genuineness of that particular photograph. So that you have to prove in the court. Traditionally, the person taking the photograph offers a testimony as to the date, time, location, etc. of the photograph. It may be necessary to offer testimony from expert witness to attest to the fact that the photograph is unaltered. So you have to call the particular expert also in the court as a witness, that that person will prove that this particular photograph is genuine and it is unaltered. So because the court believes that nowadays it is very simple to alter a photograph, though the photograph can be brightened or zoomed in some way, but in that case, you will have to produce the original photo also in the court. So same goes for the video recording also. Once one will have to mention, if you are submitting a particular video recording in the court, you have to mention the date, time, and source of video recording. Whether video was recorded on phone or it was recorded on CCTV, that you have to mention the exact source of from where the particular video came. You have to mention that also. So if the judge feels the same can be sent for forensics further, the judge will send those electronic evidences to forensics, and that then the judge will decide that whether this particular electronic form of evidence is genuine or not. So this is how evidence is made or examined in cybercrime scenes or cybercrime cases. This is how you will go ahead. Okay, so there was a very recent case I would like to talk about is Amitabh Bagchi versus Ina Bagchi. This is in regard to section 65A and 65B of Evidence Act. So the court held that physical presence of person in court may not be required for the purpose of adducing evidence, and the same can be done through medium like video conferencing also. So now it is very important, because now this is the age of digitalization. So those were the days where the the particular witness used to come to the court and give his statement. Now the court says that in case if a particular witness is not able to come to the court, also he can be made appear in the court through video conferencing, and that particular statement, that particular record will be admissible. So that is section 65A and 65B of Evidence Act. Another case is state of Maharashtra versus Dr. Praful Desai. The question involved in this case was whether a witness can be examined by means of a video conference. So the Supreme Court observed that video conferencing is an advancement of science and technology, which permits seeing, hearing, and talking with someone who is not physically present with the same facility and ease as if they were physically present in the court. So the legal requirement for the presence of the witness does not mean actual physical presence. The court allowed the examination of witness through video conferencing and concluded that there is no reason why the examination of a witness by video conferencing should not be an essential part of electronic evidence. So now this is also very important, because see, because when it comes to cybercrime cases or even in the other matters, there is a possibility that you may have problem, um, proving your case. You may have problem proving the evidence there, because in cybercrime cases it is very important to prove your particular case, and if you don't have any evidence or if you don't have any witness, then obviously your case will be dismissed. So in that case, it is very important step taken by the guidelines of the Supreme Court of India and the government also, that now if you want to present any particular witness in the court through video conferencing, that can be done. And a particular application can be filed in the court to, and the judge will probably allow that particular application, that if there is any witness who is not able to come physically in the court, then that person can come to the video conferencing. He can appear in the court through video conferencing and his statement will be recorded. So these are the few examples of, that the court has already been started implementing all these things. Now, apart from that, there's one very a very interesting case which happened in April 2001. So there was a person in New Delhi. So why I am telling you all these cases is for the reason to understand that nowadays the cybercrime cases are being investigated, the punishment are being given, they are into implementation, and the person who is a victim should not only sit clueless at the home, he should not only sit that, oh my God, what I have to do, what next I have to do now. He should go and immediately do a complaint, because the remedies are now available and the courts are now very much, attentive in all these cases. So it is not the time that if you are a victim, you will just sit at the home and you will, just say that, oh my God, what I have to done, my money has gone or my reputation has gone. No, there are remedies now. So one such kind of a thing happened in April 2001. So there was a person from New Delhi. He complained to the crime branch regarding the website amazing.com. So there was one website, amazing.com. That particular person has filed a criminal complaint against this website. He claimed that certain vulgar remarks were there about his daughter and a few of her classmates. So this particular site, amazing.com, had certain vulgar remarks of the daughter of the person, and also daughter of few of the other persons, which were her classmates. So during the inquiry, printouts of the sites were taken, the printout of the websites were taken, and proceedings were initiated. So after proper investigation, a student of 11th class and a girl of 11th class were arrested. So the juvenile board in November 2003 refused to discharge the boy accused of creating a website with vulgar remarks about his classmates. So that particular person was arrested and he was, the trial was committed as per the Juvenile Act. So this has happened. So in the year 2002 also, Mrs. Sonia Gandhi received threatening emails from the particular websites and for particular email IDs. So the case was referred and the accused was also arrested. And the accused was the person who has lost his parent during 1984 riots, and he used to give threats to Mrs. Sonia Gandhi. So that person was also arrested. So these are certain cases where the authorities and all the officials are active. So this is a case where this is a stage basically in present that we have enough instruments, we have enough technology that a particular criminal who is doing all such activities can be found and can be arrested and can be held liable. So this is not the time to sit at home and say what can be done now. Even you being a law student, you should also go to the other people and you should also spread kind of awareness in the society. That is not the time. You can go and you can just register your complaint. So this was the basic information about cyber crime and cyber laws in India. So if anybody have any questions out there, they can just ask me. And with this, I would like to hand over to the association also.
Thank you, ma'am. Now I would request you to take your questions from the people already who texted in the group, who texted in the chat box.
Right, okay.
So I would read the question for you. Is there any time frame for the police to decide cyber phishing cases?
See, there is no time frame as of now, but when it comes to cyber phishing cases, Indian Penal Code can also be involved. The sections from IPC can also be involved, and the entire process will be committed as per the criminal trial. So this particular case of phishing will be the trial will be similar to the criminal trial only. So whatever the provision of CRPC is there, whatever the investigation stages and everything is there, so everything will be applicable in phishing also. So it is same as a criminal case.
Yes, Emunashri, you can ask your question. You can just unmute yourself and ask the question.
Thanks. Good evening, ma'am. I have 3 queries. Like, my first query is, what is digital rape and what punishments will be allotted? And my second query is, actually, in the recent, starting of this session, you have told that you are dealing with a case. So what remedies you are expecting from the opponents? And my third query is, like, how we have to prove the digital evidence is original or not?
Digital evidence in what? Sorry, your voice got grabbed. Okay, so so the answer to your question is that when you're talking about the case that I'm handling.
Third question is, can I?
Emunashri, be a bit loud, no?
Yeah. How can we prove that digital evidence is original or not?
Okay, so see, for the digital evidence, you have to read Section B of Indian Evidence Act. Once you go through Section B of Indian Evidence Act, you will be clear that how can you do that. But because you have asked this question, I'm telling you that now you have to prove the originality. For example, there is a WhatsApp message. Okay, for example, you have taken a screenshot of a WhatsApp message and you have placed that on the record. You have placed that particular printout in the record. Now you have to show to the court that if you will show the particular phone from where you have taken a screenshot to the court, and if you will tell that particular details, for example, the IMEI number and the model and the color of that particular phone, and that particular phone is produced before the honorable court, that proves that this screenshot has been taken from this phone and this is original. Now, to prove that it is original, a particular expert can be called to the court, and he will a techie person basically, or he can be a software engineer or any kind of a thing. He can be a techie. He can be called to the court. He can be summoned, and that person has to be an expert. And that person comes to the court, and he can identify that whether this particular thing is original or not. So this is how you will do. The same applies for the video recording also. You have to give an affidavit under Section 65B of Evidence Act. The same applies for the video recording also, for the photographs, for the screenshot and everything. And in case there is a computer, in case you have taken a screenshot from the computer, then you have to tell the details of the computer before the honorable court. That can be mentioned in 65B of Evidence Act. For example, there's a particular certificate. What is 65B of Evidence Act? It is a certificate. So in that certificate, you have to fill all the details. For example, the model of the computer, or the phone, or any electronic device, the color of the computer or any electronic device. So you have to give all these details in Section 65B certificate, and that certificate has to be produced in the court. Now, when the court knows that, okay, these are the things, these are the electronic devices that has been used, to prove that this is original, and to prove that you have not altered or you have not modified any particular evidence, a witness can be called to the court. So I think I'm clear.
Thank you, ma'am. And the next question is, can the WhatsApp admin be responsible for the vulgar messages or anything messages in the group?
WhatsApp what, sorry?
Can the WhatsApp admin be responsible for any sort of crimes happened in that particular group?
Yes, absolutely. He can be responsible. Then, see, again, you have to prove your case. Okay, so the case can be made, a complaint can be made, FIR can be done, but then when it comes to the Evidence Act, it is on you that how will you prove your case. Okay, so that particular stage you have to keep in mind, that how will you prove your case basically. The complaint can be done, action can be taken.
Okay. Ma'am, one last question. I'm sorry for troubling you.
No, that's okay.
Is development in artificial intelligence helping to reduce cyber crimes, ma'am?
Which association?
Is development in artificial intelligence reducing the cyber crimes these days?
Yes, absolutely, absolutely. See, because in the middle of the session, I've also said that all these, forensics and artificial intelligence and all these things has to be developed. They are developing as of now, but we have not been able to reach at particular point, that we have not been able to achieve our goals. That the goals are to eradicate cybercrime in India. And when we talk about AI and we talk about all these technologies and everything, obviously they will help to reduce the crimes, but everything has pros and cons. So there are merits and there are demerits also. So but yes, when it comes to improve, they can be used as a tool for reducing the cybercrime in India.
Thank you, ma'am. I would like to request like any participants, any other queries or any other doubts.
Yes, ma'am. Madam, good evening,
Yes,
madam. I really happy for the very nice, good topic for the burning the all issues. There have my side. There are three questions, madam. The first of all, what is the carbon ref? What are the punishment?
what
Now
is
the
the
second carbon ref, madam. Carbon ref.
okay?
Now the second one, the fake institutions mean like schools, colleges, or universities, autonomous or aided. The what punishment will be given in the court? Now third question, the intelligent. Now the nowadays so many people they using drugs. The what punishment will be given in this the pro onwards? This is the three questions.
Using drugs.
Yes.
Drugs. You mean to say that they are selling or smuggling drugs online?
Yes, madam. Yes, madam. Those type of.
Okay. So see, when it comes to selling, not in case of drugs only, if you're selling any illegal, substance or anything, like obviously the IT Act will be involved, IPC will be involved, and apart from that, whatever the acts are there for drugs and smuggling, that will also be involved. So it is very simple. You being a lawyer, or you being a law student, you have to see that what all sections can be covered. So when someone is doing such kind of an activity and incidents, so you will involve IT Act also, you will involve IPC also, and you will involve the concerned smuggling and drugs act also. So that can be done. What was the second question?
Madam, no another.
Institutions.
Excuse me, madam. Another question, madam. Now the nowadays fake institutions, madam.
Yes,
The
fake institutions you're talking about.
Explain already for the website. Now the institution established fake institution like schools or college or universities. The what punishment will be given on this court?
See, when it comes to fake institutions, now see, everything whatever you're asking is very, very, very wide. Now if you're talking about fake institutions and fake colleges and all these things, obviously then again the provisions of IPC will be attracted. It will be section 420 of IPC, cheating and fraud hai. So cheating or fraud kar rahe ho, that 420 will be attracted. Apart from that, obviously IT Act will be attracted, and then it is a cyber crime if that person is particularly doing that online, and they are making fake websites, and they are trying to extort money from the students. Immediately, if for example, if there are only few incidences that a particular case can be filed, complaint can be done, FIR can be done. But if there are more than as a lawyer, I'm telling you, if you are witnessing more than 7 8 or more than that such incidents, you can also file a writ in high court.
Yes, madam.
Okay.
No, question, madam. Now the what is the carbon ref? What are act are there, madam? For the punishment.
I'm unable to understand your. Can you please message me here so that I can understand your terminology?
Now the
Carbon rape and punishment for carbon rape.
Can you please? I just want you to just mention on the message post that what exactly is the terminology.
no the madam, another madam asking madam, what is the digital rape?
Digital rape.
Yes.
See the word digital. Okay. See, you means the digital. Okay, got it. So see the word. This particular word digital rape has not been defined in any law as of now. But when we talk about digital rape, what sections are involved? Because see, under the law there is no particular provision of this particular word digital rape. Under the law you won't find this particular definition. Now, but for example, if someone is a victim of this particular such kind of an incident, then section 354 of IPC will be attracted. It will come under IT Act will be attracted definitely, but also IPC provision section 350, 354 of IPC and other provisions will be attracted, for the reason being this is a particular incident where you are trying to harm or outrage modesty of a woman. So when in any situation where you harm or outrage modesty of a woman, in that case section 354 IPC will be attracted. So there will be imprisonment also. Now it depends upon the seriousness of the offense. For example, the offense is very serious, there can be imprisonment also. But for example, if the if the particular incidence is only nobody has been harmed in that particular incident, it can also be mere an attempt. So if the incidence is less severe, there will be fine, there will be imprisonment of maximum of 2 years. So maximum will be the 2 years. But in case the offense is very serious, there can be imprisonment of life also in such kind of cases.
Thank you very much, madam, for this organizer, Kupera Pawan Kalyan sir and Lakya madam and Hari Krishna sir, the given opportunity. Really happy. 4 conference webinar we will attend it. I really satisfied, madam, but this topic. Thank you very much, sir.
Oh, okay. Thank you.
Thank you, madam.
Thank you, ma'am. Thank you for clarifying the doubts. Although the topic cyber laws in India is such a vast topic, but fortunately through this webinar, our guest speaker, Mrs. Kanika Bhardwaj ma'am, has literally spoon-fed us with the topic in a very interesting way. Thank you so much, ma'am. We are fortunate today to acquire a little amount, like really a glass of water in the ocean of knowledge that you have acquired it already. Thank you, and really fortunate to attend this webinar, ma'am. Thank you so much from bottom of my heart.
Can I put this last question, please?
Yeah, yes, you're welcome.
Hi, Kanika. My question is there any help provided by the bank authorities regarding phishing cases?
Yeah, see, now the guidelines have already been issued. For example, is there any incidents of phishing and all these things, you have to go and file a FIR within 3 days. If you are going and filing or lodging an FIR within 3 days of the from the incidents, from the date of incidents, if you are going and filing an FIR within 3 days, the bank will be held reliable and bank will be responsible and they will probably refund the amount. But in case you have delayed in getting the FIR done, then the bank will not be responsible.
Actually, this is my personal case. Around 2.5 lakh rupees has been debited from my account, from my father's account. So there was no delay in filing the FIR, but there is no as such progress in the FIR. So what other alternative we can?
So you have basically, you're trying to say that you have done the FIR. FIR is already done.
Right.
So in case, and do you know the status of the FIR as of now?
They just give this answer that they are still investigating the case.
All right. So in that case, you directly go to the court. Okay, directly go to the court, the concerned court, and file an application to know the status of your case. So from the moment you file that particular application in the court, the police officials will come to the court and they will have to answer the judge that what has been happened, what is the status of the case, till where has their investigation reached, and all these things the police officials will answer in the court.
So we can file this CWP regarding direction to give direction to the police officer.
Absolutely,
right?
Absolutely, you can do that.
Okay, thank you so much. Thank you.
You're welcome.
Any other queries from any of the participants or anyone? Okay. Ma'am, the key concepts that you covered, like IT Act 2000 or the live examples, illustrations, made us really think like what cyber law is and what are we supposed to do to protect or to enlighten ourselves in the field of the cyber law. This really created or boosted the interest towards cyber law. Thank you so much. And I would like to personally thank you for accepting our invitation wholeheartedly and enlightening everyone through this webinar. Thank you, ma'am.
Thank
And I
you
would
so
also
much.
like to thank the organizer, Pawan Kalyan sir, who took the initiative towards the social responsibility, and the association, Sri Venkateshwara Law Students Association also, and my co-host Hari Krishna sir also. Thank you so much. Thank you so much for all the participants who are here, who are being active since the starting of the webinar. Thank you so much.
Thank you guys.
Ma'am, thank you. See you soon, ma'am.
Sure, absolutely.